Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be, and we talk about cutting edge issues in the news. Today, we have a repeat and awesome guest, Louise Ryder, who is a senior attorney in our office. We're going to continue our series on federal sector litigation. So if you work for the federal government, how that process works, you might want to go back and check out the previous episodes. We walk you through kind of the very beginning. Louise did a great job of explaining kind of the opening phases, the investigative phase. And now we are coming to what happens once the investigatory phase is finished. And today, Louise is going to talk with us about the choice that you will face between choosing a final agency decision or going the EEOC route, and what that fork in the road means. But before we get to that, just some legalese. This is not intended to create an attorney-client relationship with our law firm, nor is this intended to be specific legal advice for your case. If you want either of those things, then you got it. You should go hire a lawyer. So welcome, Louise. Thanks for continuing this series. So let's pick up where we left off. You talked a lot about the ROI last time. We've gotten that. What happens next, and what does somebody in that situation need to be thinking about?
Well, thank you for having me here. And so after you get the report of investigation, you really have two immediate options. So you can request the final agency decision, which is essentially asking the agency to decide if they discriminated against you or whether the allegations of discrimination are true. I suppose you can imagine what their usual response is. I have almost never, a couple times, but almost never seen the agency admit wrongdoing in a final agency decision. So it's not usually the way I recommend. The other option is to request a hearing before the Equal Employment Opportunity Commission. And what you have to do, one of those two things within 30 days of your receipt of the report of investigation. Or if you wish to file the request for a hearing earlier, you can do that after 180 days from the start of the investigation. Or if you've made amendments, then it would be extended, depending on usually 180 days from the last amendment, but there is a time limit as well past that where you can just request a hearing.
You mean amendments to the ROI? Is that what you mean?
Amendment to the claims.
To the claims.
Mm-hmm. And so once you get that report of investigation, if you were to elect the final agency decision, again, the agency is the one who makes what they're doing is they're issuing a decision, evaluating the evidence in the report of investigation and outlining the legal standard and making a determination. And what you can do from that is that would be the cheapest option. If you wanted to hire an attorney, but you cannot afford very much, the absolute cheapest is to just ask for the final agency decision. But again, it's very rarely in your favor. But every now and then I have had clients who do that. And then once you get the final agency decision, you can appeal to the EEOC Office of Federal Operations. Now, that appeal wouldn't be the same as going through the hearing request because there's no discovery. You don't get to present any new evidence that wasn't in the report of investigation. It would just be arguing that the final agency decision was incorrect as a matter of law. So that's not the route I usually recommend, but I have had some successful outcomes with clients who decided to request a final agency decision and then retained us to appeal that decision. And what I've seen happen is the OFO occasionally, not very often, will remand the decision and say, you know what, you need to either do further investigation into this in order to make a determination, or the agency's conclusion is wrong as a matter of law. So that's an option, even if it's not a very good one. The other time that you might want to request a final agency decision where it could help you is if your goal is to go straight to federal court. So because it is the fastest, you can get to federal court faster if you go that way. If you know you're going to want to go to federal court, you can essentially request the final agency decision. And once you get that, you will have 90 days to file a lawsuit in federal court. Now, those 90 days disappear faster than anyone ever expects. And so I would always recommend, if that's your plan, try and get the complaint drafted, ready to go before you even get the final agency decision. But that, again, if you go to court, that is the best route, because then you don't have to go through the EEOC hearing route. So if you don't want to request a final agency decision, if one of those two examples don't apply to you, then you might want to probably request a hearing before the Equal Employment Opportunity Commission.
Let me ask you real quick, Louise, what does that look like? Do you get like a form? Do you send an email? Like, how do you make that election?
So generally, the report of investigation, the agency is supposed to issue you the report of investigation with a very simple one-page form that is a request for a hearing form. And what you would do then is fill out that form. It's really basic. You're not arguing your case at that point. You're just indicating that you want to elect a hearing before the EEOC with regards to the particular agency number that is at issue. If every now and then I have seen the agency send out an ROI, and I don't know why, but I couldn't find the report, or the form is missing. It's a simple search. It's a basic form. So you can always just Google it if for some reason they didn't attach it, but it really should be there.
Okay, got it. So it's a simple form. For whatever reason you don't have it, you can search for it. I had one other question before you get into the EEO request. If you go, well, two questions actually. Let's assume that someone has done this all on their own. They've done the initial phase. They've gone through the ROI on their own, and now they want to hire an attorney to represent them, with an OFO appeal. How ballpark? I know it probably varies, but ballpark, how much does that cost, and how long does that take?
The cost to go get up to the hearing point?
Yeah, but if you've gone the final agency decision, you've gotten, as expected, a finding that is against you, and you want to appeal that to OFO. How long does that take, and what kind of price tag is somebody looking at for that?
So an OFO appeal brief, it can cost $5,000 to $10,000 on average. Obviously, things vary depending on the situation, and of course, if there's a longer ROI, it's going to cost more to review a longer ROI than a short one. So that would be my guess. In terms of the time frame, you have 30 days from your receipt of the final agency decision to request an OFO appeal. And then you have 30 days after that to file your appeal brief. And I will warn you, a lot of different courts give you some flexibility on dates. When it comes to your OFO brief, you get it done in advance, because it is very difficult to get an extension of time. They will not give you more than those 30 days to get in your brief unless there are extreme extenuating circumstances. So you have those 30 days to file the brief. And generally you would outline what the facts are, what the issues are. So you would outline what you're appealing, because it has to be, and this is something that is probably much harder to do pro se, because it really depends on what legal arguments you can make based on the final agency decision, their conclusions. So you would want to identify exactly what issues you're appealing, how they made an error as a matter of law generally, and then outline the legal argument as a result. Now, so it's the 60 days from when you get the FAD until the appeal brief is filed, and the agency will have an opportunity to file one as well. As for how long it takes the OFO, that is such a big question. I don't think I can answer it. It varies greatly. I know there has been a big backlog at the OFO for some time, but I think it's my understanding that they're trying to get through it. I can't say what order they're working through, though. So I presume first come, first serve. So it can take, I've gotten some quicker OFO appeal decisions within maybe 6 months, not very often, but usually it might take a year or two for it to sit before the OFO before you get the decision.
And just to clarify, so during this time, there's no new evidence, there's no witness testimony. You as the client are not talking to anybody except your attorney. Like it's all on paper.
That's right.
And then another question before we get to the EEO process: if your objective is to get to federal court, and I think we should distinguish that they're both federal courts. They're just one is like a general jurisdiction federal court, right? Like you're talking about if you go just like you would file like a private sector case in federal court. Is that correct?
So federal district court would be where you would file once you get the final agency decision. If you're talking about appealing the OFO decision, that would be a different federal court.
Oh, I see. Okay, so if you get the final agency decision, because you mentioned earlier, if your objective is to get to, so that's where you would file in federal district court. Is that a trial de novo? Like, does it start from the beginning? Is that a review of the record? Like, how does that happen if you go to federal district court?
Yes, so it would be pretty much starting from zero. But I mean, that being said, a lot of judges they'll want to know what's already in the record, what needs to be done. They don't want to order discovery unnecessarily. They're not going to order the agency to produce documents it already produced. But for the most part, it is going to be starting from scratch, whether you're going through the EEOC hearing process, then getting a final agency decision, and then filing in federal court. You're repeating that same thing over again if you do want to go to court. If you just immediately request the final agency decision, you can then go to federal court and it still is starting all over pretty much. But you will likely have more discovery because all you already have is what's in the report of investigation. You haven't had the chance to do discovery, depositions. So yes, it will be pretty much from starting from zero.
And you had that same option even if you go through the EEO process. So if you like to have an EEO judge hear your case at the end of that, you can still go to federal district court?
Yes. So if you go through the EEOC hearing process, what happens is the judge will issue a decision, and then the agency will issue a final agency decision, generally adopting the judge's decision. And then once you get that final agency decision, the options are the same. You can file an appeal with the OFO, or you can go to federal court. And that, if you do go that route, if you've gone all the way through the EEOC process and then you go to federal court, I mean, it's not as much starting from zero because, again, judges will want to know what discovery has been done, what needs to be done. And they're not going to let you do the same things, the same discovery all over again. But, and a lot of the time, most of the time what will happen in that case is that the agency will move for summary judgment early and the case will be dismissed on summary judgment.
Because you've already got witness testimony too at that point, right? Which I guess can still be used. I mean, it can be used at the summary judgment stage.
Yes, that's correct.
Got it. So kind of, and I know kind of took you off course here a little bit. So when you're initially, you said for the most part, you would recommend folks go the EEOC route. Why is that?
Mostly it's because my clients, it tends to be a little bit less expensive to go to the EEOC. Not a lot. It's still very costly, but most of my clients would prefer the lower cost of the EEOC is one reason. And then the other reason would be that the administrative judges, this is what they do. The Equal Employment Opportunity Commission, all they do is discrimination cases, discrimination and retaliation. And so the administrative judges there are experts. They're experts in employment law. When you go to federal court, you can get any judge who has a variety of experience with employment law. And there's nothing wrong with that. But in terms of how you draft your legal motions, you always want to lay things out in a little more depth if you're in federal court, because you don't know if your judge has a lot of background in employment law. Whereas the Equal Employment Opportunity Commission, this is one of the reasons why sometimes things are faster, is instead of lengthy discovery motions, most of the time, most administrative judges prefer having a verbal conference where they go through the issues and they just make a verbal decision because it speeds things up. And so things tend to be faster, cheaper, and you have judges who specialize more in employment law as opposed to a variety of different experiences in federal court. You might get a judge that has their practice mostly in criminal law, and you might have to lay out the ABCs of employment law.
And I presume also the EEOC judges are, I'm sure they're mostly fair, but they're used to seeing some agency tricks and sleight of hand that they probably try, whereas a federal district court judge, again, just because he or she doesn't do this all day long, may not be as familiar with some of the repeat players that the judges see at the EEOC stage.
Absolutely. For instance, if you have an issue where, and I have had this come up a few times, where a small subcomponent of, say, the DOJ, for instance, will say, oh, well, we don't have access to those documents because the DOJ made that decision. It's not this particular sub-agency. And the administrative judges have generally encountered that situation before, and they'll know that there's a process in place to get those documents. It just might be more cumbersome, but the agency has the ability to do that and can be ordered to do so.
Got it. And then just to back up to clarify one thing, when you said the EEOC process is less expensive, you mean less expensive than going final agency decision to district court? It's more expensive than if you just go final agency decision just to roll the dice and see what happens, right?
Yes. Yeah, the absolute cheapest, and honestly, you could do it without an attorney. Just request a final agency decision, see what they say. And if it's adverse, you would probably need to hire an attorney to file an appeal. But it's also, that's the cheapest option, but it is also more risky, you're more likely to lose. And also, once you get to the OFO, it's not something where you can say, you know what, let's see what'll happen, and then I'll hire an attorney. I would not recommend that, because once you get the final agency decision, you can appeal to the OFO, but it's not considering any new evidence. It's only considering what's in the report of investigation. And those are the documents usually that the agency has been asked to provide, but agreed to provide. And a lot of the time, documents that can make or break your case are missing from that, and you can't introduce them at the OFO.
Yeah, that makes sense. And then I think it's important too, just from a human perspective, like wanting to get your story heard, really, except for the initial process, the EEO process, where you maybe, you're talking to an EEO officer there, you're not talking to anybody through this, right? Really, you're talking to people, but like, it's not like you're before a body that you can explain what happened. Going through the ROI process is a paper process. Yes, you can submit affidavits and things like that, but it's not like you're getting to say your piece. Same if you go with a final agency decision or an OFO appeal, like you're not talking to anybody, like your attorney's doing the talking or you're doing it on paper. Really, the EEOC process, either that or in federal court, but you'll get there more quickly, it sounds like, with the EEOC process. You get to tell your story, right? You get to testify. You get to have, people from the agency testify. Like there is an airing of grievances, from the Seinfeld reference. There is this ability to kind of tell your story. Whereas prior to this, we're talking months and months and months of paper back and forth, which can, it's an important part of the process, but it's in terms of like feeling like some kind of resolution, feeling like you've been heard. Really, this is the first stage where you get, win, lose, or draw, you're going to get somebody who's going to hear your story.
Absolutely.
Got it. So I think that's a pretty good overview for folks, unless there's anything else you want to add about how you make that decision about that fork in the road.
Not at this time.
Great. Well, we will we'll end this episode, and then we'll pick up the next one where we will talk about what happens once you get to the litigation process at the EEOC stage. Well, thank you for joining this episode of the Spiggle Law Firm podcast, where we talked again with Louise Ryder about the federal sector litigation process. And in this episode, we talked about that fork in the road. You've gotten your report of investigation, and now you have to decide whether you want to have your matter heard by the EEOC or whether you want to continue with an agency for a final agency decision. In our next couple of episodes, we'll talk about the litigation process that occurs at the EEOC. If you like this and would like more of this kind of information, you can go to our site, thecareerrocket.io. Give us your email, and once a week, you will get cutting edge employment law information in your inbox and information about how you can stay on the balls of your toes at your work and keep that upward trajectory. As always, you can find more information at our website, thespiggellawfirm.com. Finally, if you enjoyed this episode, feel free to send it to a family member or a friend. We're trying to get the word out to as many people as possible. In the meantime, good luck out there, folks.